Welcome to the 5th edition of Euroquestions. Today we welcome our Senior Research Fellow, Eulalia Rubio, who will present the compromise reached by the Council and the European Parliament over principle of rule of law conditionality in the attribution of European Union funds. She will discuss where negotiations stand presently and evoke potential oppositions by Hungary and Poland, who have threatened to veto the recovery fund if they are unhappy with the agreement. Please do not hesitate to ask your questions throughout the webinar by using the Q&A tool available on your screen. Eulalia Rubio will answer them in the second part of this webinar. Without further ado, I leave the floor to Eulalia Rubio for her presentation.
Thank you, Mathieu. Thanks to all. So when we planned this webinar, we were not sure that it would be so timely, but actually this week is very timely, the question of the rule of law. What I want to do just as a sort of introduction is to explain to people what was in the political compromise achieved between the Parliament and the Council on 5th of November. And then we will leave the question open, what will happen now, where we stand and what will happen now. So just to understand people, what was this compromise actually? The compromise was difficult because the positions of the Council and the Parliament were quite different in many points. There were four main points of this agreement. One was the scope of the instrument. The Commission had proposed this rule of law conditionality mechanism as a mechanism to be used to suspend funds in case of any generalized deficiency of rule of law, without having to analyze exactly whether there had been an irregularity in the use of the funding. But the Council proposed a very narrow scope of instrument actually in its negotiating position. It proposed to really narrow down the instrument to something only to be used to suspend funding in case of irregularities, proof irregularities in the use or in the control in the use of the EU funding. So that was a point of disagreement. The Parliament asked, on the contrary, to even broader more the scope of the instrument than what was proposed by the Commission. There was also the question of the decision-making rule to adopt sanctions. There was this distinction between, the Commission in the original proposal and the Parliament also endorsing the use of reverse qualified majority voting that gives a lot of power to the Commission. It's the Commission who proposes a sanction, and this sanction is adopted unless there is a majority of member states against it, whereas the Council rejected the use of reverse qualified majority voting and asked for using classic qualified majority voting mechanism. There were also some minor disagreements on the procedure, and we will enter into this later on, but basically there was a demand from the Parliament to objectivize a bit more, or to reduce the degree of political discretion of the Commission by creating a new institution, a Council of Independent Experts that would assist the Commission in the analysis of breaches to the rule of law. And also on the side of the Council, there was an attempt, we could say an attempt to lengthen a bit more, to increase the length of the procedure, because many time limits included in the procedure to assess the existence of rule of law and to propose sanctions were quite lengthened, quite extended, so that could eventually lead to a very long procedure. And that was something the Parliament didn't agree to. And later, the last point was there was a specific request from the European Parliament to strengthen the provisions to protect final beneficiaries. The problem with this kind of mechanism is that if the EU suspend the payments to one member state, there is always the possibility that this member state does not pay to the final beneficiaries, even if they have the obligation to do it. They simply say, well, Brussels is not paying to us, so we are not going to pay the final beneficiaries. And the Parliament was very adamant on the need to prevent this to happen, and asked to reinforce the provisions to prevent this situation to happen. So I will enter into detail on these four elements. The scope of the instrument, as I said, there was this attempt from the Council to reduce it to only instances in which there was a proof irregularity in the use of the funding or in the control in the use of the funding. This was somehow a win from the Parliament, because this did not happen. Actually, the scope is larger than that. There has been a change in wording. Now we talk about breaches of the principle of rule of law instead of generalized deficiencies, but that can be seen also as a positive thing, because that gives that somehow broadens up even more the scope. We are not, or the Commission the Commission does not need to prove that it's a systemic violation of the rule of law. If there is a breach that is important in itself, it is already one instance that can trigger the instrument. And another win from the Parliament was that it was included a broad indicative list of breaches. Just indicative, that does not mean that only this type of breaches are the ones that can trigger the instrument, but it is quite broad, and particularly it mentions in specific, it explicitly mentions the question of independence of the judiciary. That was something that the Parliament really wanted to have included in the text. There is also a win from the Parliament in that the preventive approach has been maintained. So as I say, it's not only in case in which the Commission can prove that there has been a malfunctioning in the use of the EU budget that the mechanism can be applied. It has to be proof that this breach of in the principle of rule of law can affect or risk affecting in a sufficiently direct way the management of the EU budget or EU financial interests. And again, there is a broad indicative of list of situations in which this can happen. And there is also a small win from the Parliament because they succeeded in including a specific mention to tax fraud. So in case of a breach of something that seriously affects, for instance, the well-functioning of public authorities in charge of combating tax fraud, that can be a case, that can be a situation that can trigger the mechanism. And beforehand, there was no explicit mentioning to tax fraud. There was mentioning, for instance, to fraud and corruption in the use of public spending, but not the taxing, the tax part of fraud. And last point, well, there has been also an explicit mentioning to the fact that rule of law has to be interpreted in a very broad term and has to be understood as having regard to the other union values and principles enshrined in Article 2 of the treaty, that is all things related with democracy and fundamental rights. On the rule to adopt sanction, I already said there was this discussion of this conflict between whether using qualified majority voting or reverse qualified majority voting. In this case, it's the Council who has I mean, it has been retained the position of the Council to use qualified majority voting. The procedure has not really changed a lot, so the Council shall decide within 1 month of receiving the Commission proposal of a sanction. And there is also this so-called emergency break that was originally included in the text to try to satisfy the demand of Hungary, so that it allows one country to request to discuss the matter in the European Council if it considers that the Commission proposal violates the principles of objectivity, non-discrimination, and equal treatment between member states. But in any case, that can lengthen indefinitely the procedure, because the Council is requested to decide up to maximum 3 months. And there is a specific mention to the possibility of the Commission to use Article 237 that actually gives the Commission the possibility to introduce things in the Council's agenda, so that it's a way to ensure that the Council will decide on time and there will not be, temptation to leave the thing unresolved for a long time. On the third element was the overall procedure, so the procedure by which the Commission assess if there is a breach on the principles of rule of law. There has not been many substantial changes, neither. As I said before, the Commission, the Parliament had asked to introduce this panel of independent experts, and this has not been accepted by the Council. So it will be the Commission alone doing this assessment, but there is a small reinforcement in wording in the sense that the text says explicitly that the Commission shall take into account decisions, conclusions, and recommendations of other union institutions and relevant international organizations. And beforehand, it was only may take into account. So, some sense the Commission has to justify its assessment on the basis of, conclusions and reports and recommendations of, for instance, the Court of Justice or OLAF or the new European Prosecutor Office, or also the Venice Committee that is explicitly mentioned in the preamble of the text. There is also novelty. It is explicitly said that this mechanism is going to be used as a last resort mechanism in the sectoral legislations of the different new programs for 2021-2027. In many cases, it has been also reinforced the capacity of the Commission to suspend funds in case of malfunctioning of the use of the funding. And by this reference of the fact that other procedures can be set out before that. It's a way of saying that we have other bases to activate, to suspend funds if we have, for instance, a real proof of an irregularity in the use of funding, and that this mechanism will be only used in case the other provisions set in sectoral legislations do not allow us to do this suspension. And we are in fact in front of a case in which we know that there is a risk to affect the management of the EU budget, but we don't have the proof of it actually. And as I say, also there was this question of the length of procedure that the Council had tried to really extend a lot, and it was a demand from the Parliament to shorten it, and it has been shortened to maximum 7-9 months, down to the 12-13 months that was initially requested by the Council. And last point, it's the point on the protection of the final beneficiaries. As I say, and as I said before, it was a very important point for the Parliament, and rightly so, because if it's not, I mean, if we don't have the capacity to protect final beneficiaries, it's true that there is always this risk that the Council or the Commission do not dare to put into place these sanctions, do not dare to propose sanctions because of the economic cost that it can have for the final beneficiaries. It was already said in the text, in the original text, that the member states have the obligation to continue payments to our final beneficiaries, even if the funds from the Commission, from the EU budget are suspended. This obligation has been a bit reinforced, and particularly it has been reinforced with an obligation to regularly report to the Commission in case of funding that is under shared management. So that is, for instance, the typical case for cohesion policy, that is funding that is managed by the member state. So the member state has to regularly report to the Commission that he's maintaining this obligation, he's doing the payments to final beneficiaries. There is also a novelty that was proposed by the Parliament. The Commission should set up a website to assist final beneficiaries and also to allow them to inform on any breach of this obligation from member states to do these payments to final beneficiaries. And in case of no compliance, actually the Parliament had proposed something a bit more ambitious. It had proposed that the Commission could eventually stop payments to intermediate public authorities in the sanctioned member states, transfer up these payments to these amounts to the EU budget, and reprogram these amounts through a mechanism that exists in the EU budget that is called global margins for commitments, and to try to reprogram them in a way to the maximum extent to benefit the final beneficiaries. This has not been retained. I think it's also because for some legal reasons, it's very difficult to shift money that is under shared management to central management. And what the text now says is that the Commission shall do, if it's not complied, this obligation of member states to pay to final beneficiaries, the Commission shall do its utmost to ensure that this obligation is honored. And how? By using the basis that we have in the fund-specific regulations. For instance, in the case of cohesion policy regulations, there's the possibility for the Commission to do what is called a financial correction, to reduce, to stop payments to a particular program, and to somehow push, oblige the government to reprogram this funding if these funds are misused. But there is no, what is important to retain is that there is no capacity for the Commission to step in and replace the member state in doing this. So that's the compromise reached by the Parliament and the Council some weeks ago. And where do we stand now? That's the question. As you may all, most of you have followed, this text had to be was discussed yesterday in the Council of Ministers of European Affairs, and the idea from the Council was to adopt it, and it was in parallel. There had been also the agreement on the MFF regulation with the European Parliament. So the idea was to adopt these two texts, and at the same time to adopt the so-called decisions on resources that has to be adopted by unanimity by the Council, and that is important and is essential to trigger and to put into place the recovery instrument by January 2021. But we knew that there was this threat from Hungary and Poland to block the adoption of the decision of own resources and the adoption of the MFF, both legislative acts subjected to unanimity. if the rule of law conditionality mechanism was not to their liking. And it's what happened yesterday. Yesterday, the Hungarian and the Polish minister decided not to adopt, not to vote in favor of these two pieces of legislation, the MFF regulation and the arms legislation, that, as I said, are subjected to unanimity because they do not agree. They consider that the rule of law mechanism is not what they wanted to. They consider, in particular, that it has not been done by taking into account what it was agreed in the historical European Council of the end of July, which in fact ended with a very ambiguous wording on rule of law mechanism, which led to different interpretations actually what was agreed in this European Council. So now we will see what will happen. There are now, I mean, at the moment we are talking, of course, there are discussions and the change at the EU level among ministers and among member states to see how to resolve this particular problem. So I stop here and I look forward to change with the people listening on this question.
Thank you. So I think I'll start with the question with regards to the state of negotiations now. Do you think there's a risk of the instrument not being adopted at all because of Hungary and Poland's veto?
I think there are different possibilities that what might happen. I do not think, I think it's very likely that the text of the rule of law mechanism is reopened, because the European Parliament has been very clear right after the veto in saying that they are not open to discuss again the text, that the text has been already agreed, and they do not agree to the idea of renegotiating the text. And also some member states have been very adamant, saying that they do not want to water down the compromise on rule of law. So that, for me, it's not an option that is very likely to happen. What is more likely to happen, at least in the very short time, is to try the typical solution at the EU level, which is try to keep the compromise by doing some wording and by doing some some declarations of how to interpret this mechanism. So maybe with a political declaration, non-binding declaration. Maybe yesterday, for instance, in the Council of the Ministers of European Affairs, there was the Commissioner Hahn, and the Commissioner Hahn also said very clearly that the Commission wanted to objectivize as much as possible the procedure, and he commit himself to develop implementing legislation or acts to clarify how the Commission will do this assessment, because has been one of the criticisms from Hungary and Poland, that it is too discretionary and it does not maintain the quality among member states. So there will be attempts to try to clarify the way both from the Commission and the Council, I think, the way they will interpret and they will use this mechanism. I do not think they will change the mechanism as it is written in the text, because it's very difficult. That's what I think.
Thank you. So the next question concerns the action of the European Parliament. You mentioned a small victory for the European Parliament. How do you analyze the role of the European Parliament in this negotiation and more generally in the COVID crisis?
Well, I think I don't know if I say a small victory, but I think maybe I say it, but I think I was wrong, because I think it's a very big victory. Actually, it's a victory not only on rule of law, but on at the same time than the compromise on rule of law was achieved. There was a compromise on the MFF, and if you look at the compromise on the MFF, that's a very nice victory actually from the European Parliament. The European Parliament was in a very strong pressure to arrive to an agreement, if you remember, because everybody was very stressed about the idea of having some delays. And in the end, they succeeded in having quite a nice amount of money, a supplementary amount of money for these flagship programs, 15 billions, which is quite a lot. And if you compare to past MFF negotiations, it's quite historical. Never before the Parliament had obtained such a big amount in relative terms. I mean, not in on absolute terms, of course, it's difficult to compare because of inflation and changes in currency also. But in relative terms, have never had such a big amount of money compared to the total amount that the Council had proposed. And it's an important agreement also on two other basis. First, because this increase has been done without touching the ceilings agreed in the European Council of July, and that was very important. That was a red line for the Council, and that makes more realistic the possibility that allows the Council to adopt it without renegotiating the wall, touching, the political equilibrium reached at the end of July. And secondly, this increase has been done through by introducing a new practice that is using the revenues from fines especially fines from competition policy, which is something that Parliament had asked several times before, and the Council had never accepted. That is only introduced ad hoc for this 15 billion. But if this becomes permanent, and this becomes a principle in the future, that it's a very interesting thing, and it's a success for the Parliament, because it's a new revenue actually for the EU budget. Even if it's not called own resources, it's a new revenue that can collect an important amount of money, actually comparable to what can be collected, for instance, through the famous digital levy that is one of the new own resources that is under discussion. So I think it's a very big victory for the Parliament, both for the rule of law and for the MFF. And let's see what will happen now with the third legislative, with the whole package actually, because of this veto of Hungary and Poland.
Thank you. So why do you think so much progress has been made now on the question of rule of law conditionality, when it's a question that has been raised in the past years several times by EU institutions?
Well, I think that it is clear that the situation in Hungary and Poland has worsened, and it has become a real problem for the EU as a whole. And actually, I mean, it has been something that has been growing up gradually, and I think particularly the case of Hungary has become quite worrying for several reasons. At the same time, it has been very much realized over time that Article 7 has its limits, and in the very end cannot be really credible, because it's always subject to unanimity. And third one, maybe it has been also realized that that positive or constructive dialogue, which has been an alternative strategy taken by the Commission to deal with this kind of problems, does not really work when you are in front of a country that is intentionally reaching the rule of law, because it has a strategic plan to change the regime. Actually, it's not just a punctual violation or problems with the control of the corruption. When you are in front of member states that have an intention to a strategic vision to change to weaken the democratic basis of their regimes, it's very difficult to resolve this just through dialogue, actually. So that's why there was a need of something more substantial, more robust, and more effective. And it was something that came over time. The idea that these countries are also it happens to be countries that are net beneficiaries, so they receive a lot of money, and it became a bit at odds that they receive quite a lot of EU money, and at the same time they do not respect the basis of the basic principles that sustain the EU integration process, actually.
Thank you. So the next question is quite interesting. Was it a mistake to link the MFF with the recovery plan? The recovery plan is due to give money to member states to help them to cope with the COVID crisis. Now all seems blocked for political reasons, when the money is urgent in some cases.
So that's a difficult and open question, actually. I have no simple answer to that. I think if everything goes well in the end, we will be very happy that it is linked to the EU budget, because it's objectively it's much better. It's superior to having something intergovernmental out of the EU. And we have seen the problems with intergovernmentalism, with the ESM, subject to unanimity, with the rigidness to adopt to authorize every payment authorization. It has to be validated by all member states. So I think from a pure technical perspective, and also political perspective, because it's a way also to reinforce the EU budget, it was much better. Now, of course, if it fails, it fails. But do not forget that what makes problems here, the obstacle is the rule of law conditionality mechanism. Actually, A more pertinent question would be, it was a mistake to link the rule of no conditionality mechanism to the whole package, the recovery MFF package, because imagine that the rule of law conditionality mechanism had been adopted beforehand, for instance, we would not have this problem now. So there was no need, no legal need to link the rule of law conditionality mechanism to this whole package. There was a political vision to do it because it was seen as a good opportunity to change the rules in the management of EU budget, and also as a way to create a bit of leverage to pressure these member states, because they of course if they block this, that, I mean, for the parliament was a way of having some leverage and saying, well, if you and it has been used by the parliament actually, if you do not agree on our vision of the rule of conditionality, we will block the MFF. But it had been also, I mean, it can be seen as a positive or as a negative thing. It has been also risky in this sense, because it puts all the world package in danger now.
Thank you. So another question from a participant is, was the last EU budget so complicated to negotiate, or is it this year with the link to the recovery plan which create complications?
All MFFs are complicated to negotiate, and the last one we should not forget, it was also delayed. Actually, it was decided at the very end in December of the last year of the previous MFF, and it started with some delay, and actually that created a lot of problems for 2014. That was the first year of the current MFF, so it was not easy. The last one, the main problem was that it was negotiated in the middle of the crisis, in the last crisis, and there was a strong pressure from member states to reduce the amounts, particularly from some member states. And in practice, the parliament was not very successful in the negotiation, and the parliament could not challenge the amounts proposed by the council in the last negotiation. It had to accept the amounts proposed by the council, and it only obtained marginal victories in terms of more flexibility, the establishment of a high-level group to reflect on potential new resources. But it was quite frustrating for the parliament, and it has been something, I think, that has marked also the negotiation and the negotiating team this time, because they were very aware of the difficulties last time to negotiate, and they wanted to, and it has been they prepared themselves well in advance this time, because they had this bad experience of the last negotiation.
Thank you. Another question, are there any news on whether the EU Parliament will have a monitoring role on member states' expenditures?
Well, the Parliament has a surveillance of member states' expenditures when they are inside the EU budget, and the question is what will happen with the next generation EU, actually, which is not inside the EU budget. There has been a small victory in this sense from the Parliament, because in this MFF agreement, the agreement on the MFF regulation, the Parliament has obtained the possibility to monitor annually the use of this money coming from the next generation EU. So there will be one moment at the year in which the Parliament will have this capacity to report. I mean, the Commission will have to report to the Parliament on how these external assigned revenues that comes from the next generation Europe are used and are distributed among different EU spending programs. So that's a bit more than was allowed from the beginning, because normally for external assigned revenues, which is the title of this type of revenues coming from next generation EU, the Parliament does not have any right to oversight. So that's a small victory. Then the big victory, or the big thing that is still open, is what will be the role of the Parliament in the governance of the facility, which is the main program that is financed by this next generation EU, and is the program that is financing national recovery plans. This is still open because the trilogues on that have just started. And what we know for the moment is that the Parliament asked to have equal foot, to be treated equally with the Council, so that they want also to have a say on the adoption of national plans and on the authorization of payment installments. But that's not granted. The Commission does not agree, and so we will see what happens. I cannot say more because this is still under negotiation.
And probably the last question for today, we talked a lot about the European Parliament, but this question is for the German presidency. How do you judge the role of the German Council presidency in this process of negotiation?
I think it has been very good. I mean, they have done a great job. It was not easy, and for instance, for the compromise on rule of law, they have really played quite well. They have they have found a compromise that is sufficiently, uh, I mean, seen as sufficiently robust for Parliament to be accepted, and at the same time not going too much on the on the side of the Parliament and on the side of some member states that wanted something much more effective and strong. So in general terms, I think they have done a very good job. At the beginning, they were quite in a rush, and I know that they put a lot of pressure to the parliament to have to a compromise on MFF and especially in MFF. But I think in the end, I mean, you can see that it's a big member state with a lot of experience, so they have really done a very good job. And let's see what will happen now. Now it's a bit on the ball also to deal with the problem with Hungary and Poland. So we all expect a bit what will happen with this problem, or how Merkel will deal with that. So I think it has been lucky for the EU, I think, to have big and experienced member states now at the presidency. Actually.
Thank you. So before closing this webinar, I take the opportunity to present two recent publications from the Jacques Delors Institute on the question of rule of law conditionality. So Eulalia Rubio's publication, Rule of Law Conditionality, What Could an Acceptable Compromise Look Like? And published today from our Vice President Christine Verger, Bras de fer entre le Parlement européen et le Conseil sur le budget de l'Union, des vainqueurs, des vaincus, which will be published in English shortly. It analyzes the negotiations between the Council and the European Parliament over the question of rule of law conditionality. Thank you for following this webinar. The recording will be available on our website and our YouTube channel, and we hope to see you next time. Goodbye.
Bye.